Hi everybody, this is Arkady Frekhtman, a New York City personal injury trial attorney. And in this video, we're going to learn how to settle a case. Do you want to find out the ins and outs of how to settle a case and get the best recommendations, not just from lawyers, but also from judges? Well, yesterday I did a CLE, which is a continuing legal education. And there was not one, not two, but 3 judges present, and they gave their advice for the ins and outs of how to settle a case. And there were a lot of lawyers. I think 500 lawyers were present, and they had a really nice discussion, very frank discussion about some of the issues. And I thought I would share it with you. I have my notes from the discussion, and I thought I would share it with you because it was really interesting. I know a lot of you have your own personal injury cases. You may have just been in an accident. You may have a lawyer. You may just be interested in what something may be worth and how best to go about settling it. So let's get into it. So this was a CLE put on by the New York State Academy of Trial Attorneys. And there were a few judges. One judge was a judge who was actually the administrative judge in Manhattan. And he ran a lot of the courts. He actually was one of the judges that was responsible for making the courts move faster. Because before, you would file a note of issue and certify a case as trial ready, but then you get stuck waiting on the trial calendar for like 2 years, 3 years, 4 years. And this was a judge who made it quicker. He put in these standards and goals. So you only have to wait about a year, maybe even sometimes less than a year. So it really worked in Brooklyn, Queens, Staten Island. And I think he was about to do it in the Bronx, but then COVID hit and he ended up retiring. And then he went into private mediation where he worked for a company and he was a mediator. And now he's still a mediator, but now I believe he opened up his own company. So he has his own company. And then the other judge was kind of like a judge who took over for him. So when he retired, this other judge became a judge in Staten Island and New York. And then there was a third judge from the Bronx who's an active judge. So basically they said, the first thing they discussed was they said, what's important? If we want to settle a case, if we're trying to settle a case in front of a judge, what is important? And they said to be really important is just to be honest and be frank about your case, meaning the strengths of your case and also the weaknesses of your case. And as a lawyer, you have to, be able to view it objectively, because I know every person thinks, oh, I have the best case, I'm entitled to, millions of dollars, but sometimes that's not true. So as a lawyer, you have to be able to view it objectively, and you have to be able to see the other side's argument. And also, one of the really important things that you have to be able to do is maybe show the case to a neutral group, like a focus group. Sometimes it's very cheap. You can get people to participate in an hour-long focus group for like $7,500. And then, you ask them questions, you give them a neutral presentation of the facts of your case from the plaintiff's perspective, from the defendant's perspective, and see what they tell you. That's what a jury's gonna do, right? They're just like jurors. So it's really, really a good idea. In fact, maybe in the future, I could present some facts here and see what you guys think, right? Because this is almost like a forum where we have so many viewers and we can get people's opinions. We could almost use this as a focus group. So they said that's really important. And the judge gave an example. She said she had a wrongful death case where the person who died had their own business, but they only were showing like 10 or 13,000 in income on their taxes. So they didn't have much economic damages. And in New York, we can't sue for other things for wrongful death. It's mostly a pecuniary statute. So then the person who died also did not see his or her adult kids in decades, and he had no minor kids. So they said, look, this case has limited value, but the plaintiff thought, oh, because it's wrongful death, it's worth millions. And then the judge said, look, what ended up happening was I turned out to be right, because, these judges, they're there for like 20 years, 30 years, day in, day out. They really know what the jurors are going to do. They really know what these cases may be worth. So that was the first thing, that be honest, be frank. And that's one of the themes that I've talked about before in my videos. Like when I do jury selection, I often say, what does brutal honesty mean to you? And then I try to have that theme of brutal honesty, that we should be honest and we should say what we really think. So then they also went into, getting the plaintiffs back to reality and discussing the case with the clients and managing their expectations. Then the other thing that was a big pet peeve of everybody, they said, look, the one thing that I hate is when a lawyer shows up to a settlement conference in court or a mediation and they don't know their file. They don't have, for example, a demand, meaning they don't know how much it would take to settle the case. They don't know the file. Sometimes lawyers use these per diems to go, but you don't want to use per diems for that. Or young attorneys. Young attorneys are great. They should be, second chairing lawyers at trial or doing depositions, but you don't want a young attorney to go to a settlement conference because they may not understand all of the implications of how that works. And so one judge was talking about, STP, which is the settlement trial part in the Bronx, and she said it's not a place for a newly admitted attorney. And then they also discussed in-person versus virtual, and a lot of them said, yes, virtual is great, but sometimes, in-person is maybe a little bit better because you get to really talk about the case and you get to really meet people with more interaction and see how people's facial expressions a little bit better. So they prefer it in person if possible. So then they also went into, one of the reasons they said that some of these cases settle, and there were substantial settlements. Like one case I think settled for $1.5 million. But the reason it settled because the client in that case, the plaintiff said, look, I do not want to go to court. I'm scared. I don't want to testify. And some people are like that. Some people are just like, look, I don't want to go to trial. So just get me the best offer. And that just happened to be 1.5. So who knows what would have happened if that person would have gone to trial. They might have been scared and be like, oh, I can't testify. And then gotten zero, gotten much less. Or they might have been able to manage their fear and testified okay, and then maybe gotten more. We just don't know. But sometimes people just don't want to go to trial. I've had that too. I've had clients tell me, look, I don't want to go to court. Do whatever you want to do, but I'm not going to court. And then when there are substantial offers, either in the settlement, especially in court, right? When there are substantial offers, what these judges like to do is they like to allocute the plaintiff, which means, put the plaintiff on the stand and then confirm that that is their goal. So for example, if the defendants say, look, we have $950,000 today, and then the plaintiff's lawyer says, you know what, that's too low. I'm looking for $2 million. What the judge will do is she'll take the plaintiff because she wants the plaintiff to show up because they already have like a trial date coming up. This is one of the final settlement conferences. Get on the witness stand. There'll be a court reporter writing everything down, and the judge will say, okay, plaintiff's attorney, please allocute, please, confirm this on the record. And he'll say, do you understand that you've been offered $950,000, that you're rejecting this offer? And they have to say, yes, I understand. I fully understand. You understand that if you reject it and we go to trial, the jury could allow for nothing, and you could get a defense verdict, and then the $950,000 will disappear. And then, by explaining all these things, all the different possibilities to them, what happens is people sometimes think, oh, you know what? Maybe I don't want to say no to $1 million or almost $1 million. Maybe, and then she said, the judge said that a lot of times these allocutions on the record like that, confirmations on the record, that will get the people to either, change their mind and agree to the settlement, or what will happen is maybe the defendant will come up. So if it was $950, they'll say, you know what? Okay, I understand. I have a little more. I can get 1.1, and then it'll settle. So she says these things are very, very effective. And then the other part that was very, very important was they said, look, you have to know your liens, right? Because there could be a lien on the file, either from funding. People take funding, pre-settlement funding. Say you take $5,000, it might grow. Now you owe like 15 or 20. So that could affect your take-home pay. So then you can't really negotiate a settlement if you don't know how much your client is going to walk away with. So funding, Medicare liens, medical liens, meaning liens from doctors, liens for surgery, that's very, very important. And then one of the judges said, look, I really I don't like some judges will split it in half. So for example, if I come in and I say, look, my demand is $1 million. And then the defendant shows up and he says, you know what, that's way too high. This case is worth $100,000. So then a lot of judges will say, well, how about we split it? How about, we try to get it for like 500. But these judges actually said that doesn't always work. So what they like to do is somehow, they called it bridging, kind of like bridging, seeing where we could bridge it. Maybe like almost like traveling down a river. There's a lot of twists and turns, but how can we get both people to the same place? That's what a lot of the judges try to do in mediations. And so they said, look, I mean, no plaintiff is going to be happy with the first offer, meaning that you should not expect a reasonable first offer. The difference is sometimes drastic. And I've done videos about it before. I've had cases where the first offer was like $15,000 and then the case would settle for like $1 million. So wait a minute, how did you think this was worth $15,000? You know, so, and then they said no defendant is happy with the first demand. And you know, everyone uses this word demand. I don't like the word demand. I like the word more like settlement opportunity, because when I send my letters that I talked about also in prior videos, I like to say, look, the case is worth $1 million, let's say. Pay that within 30 days. If you don't, that's fine. But then you'll never see this $1 million again. Now the minimum amount that we would accept is going to be like $3 million. So, you know, guide yourself accordingly. Do whatever you have to do. But this is like your opportunity. Hey, you have this chance. You know, I'm flipping it over, flipping the script and giving it to them. Hey, this is your chance to settle the case for a fair number. Why not do it? You know, protect your policyholder, protect your insured. So I like to really, you know, negotiate from a place of strength, and I like to flip the script, because a lot of these negotiations are the insurance company is like this $1 billion, you know, strong insurance company, and you as this lonely plaintiff are lucky that you're going to see anything, right? So whatever we offer you is almost like a gift. You better be thankful for it. That's the kind of like the framework, right? That's kind of like the mindset. I don't like that, so I just don't play that game. But it's going to take time to change the way everybody speaks and just the way everybody thinks about it. So, yeah. And then this other judge, the one from Staten Island, was saying that, you know, if an attorney's never been to Staten Island before, if they don't understand Staten Island jurors, if they don't understand our mentality, then they may get it wrong. They may say, look, I think I have this argument. Let's say whatever it is, maybe you have an issue with liability, or maybe you have an issue with damages. Like with liability, you could have an issue that the plaintiff, I don't know, didn't look where they were going, for example. Or with damages, you might have an issue that the plaintiff fell down but didn't get any treatment for like 2 weeks, and then after 2 weeks later started getting treatment. So she didn't say what this issue was, but she told the plaintiff's attorney, look, this issue is going to be a problem for you in Staten Island. This is a judge who's been in Staten Island for like many, many years, like 20 years more, knows how the jurors think. And the attorney, you know, he was never in Staten Island before. So he said, that's not going to be a problem. I have this explanation. And she's like, that explanation is not going to fly. And it turned out the judge ended up being right. And the lawyer either lost the case, got very little, or, you know, she didn't say specifically what happened, but, you know, the judge ended up being right. So sometimes you have to listen to the judges and really kind of like listen. And that goes back to using a focus group, independent people. You know, you can't really be married to like one concept of what you think a case is worth or what you think people are going to believe, because you never know. Sometimes cases get decided on the weirdest things. Sometimes even like jurors decide cases on issues that are not legally allowed. Like the judge will say, look, this is the law, but they'll decide it on something else, or you never know. So a lot of it is like, you know, I don't want to say a crapshoot, but a lot of it is very, very open. So you have to be malleable. You have to be able to roll with the punches. And then they talked about bracketing. So bracketing basically is, you know, for example, if they say, I'll go to a number, for example, I'll go to, let's say, I don't know, let's say, I don't know how to explain it better. Maybe like, I'll go to X if you go to Y, right? So that means that, for example, you start a negotiation and the plaintiff comes in and they says, I need $7 million on this case. And the defendant is like, $7 million? What are you talking about? All I have is like, you know, maybe $175,000. This case isn't worth that much. So the way bracketing works is the mediator might say, look, you're at $175,000 offer. You're at $7 million. How about we say that we try to get this case anywhere from $200,000 up to $2 million. And then at least we have some sort of a bracket, you know, from $200,000 to $2 million, and let's work it off. And the judges who do these mediations say that oftentimes the middle of the bracket, right, so from $200,000 to $2 million, the middle of the bracket is about $1 million. That's where the case usually settles. So that's how brackets work. So you just kind of set up, and they do the same thing in trials. Sometimes with trials, you have something known as a high-low. So for example, I can go to trial, and then, the jury doesn't know about the high-low. So the jury could allow for 7 million, or the jury could allow for, nothing. But I have a low. My low is, say, 200,000, and my high is 2 million. So then if I hit for 7 million, well, I don't get 7 million, I get 2 million. But if I get a defense verdict, I get 0. I don't walk away with 0, I walk away with 200,000. So it offers a little protection. That's known as a high-low. So that's something that's done as well. And then we talked about, I did other videos before where we talked about these summary jury trials. Those are usually for small cases, like 100,000 or under. Usually, I mean, you could do them for bigger cases. I don't like to do them for bigger cases because I find that they're kind of disrespected. The judges don't like them so much. They are very, very strict with your time limits. Like if you're trying to give like an opening statement or a closing argument, and they say 10 minutes, and then like, as soon as it's 10:01, they're like, that's it, just shut up, sit down. You can't even like present your case. So I don't know. I feel like they're okay if you really like are able to, consolidate your case in a 10-minute closing. They're okay if you but for small cases, I would say 100,000 or less. I wouldn't do them for big cases. Big cases, you might as well just go to full trial. And then the final thing they talked about is they said, look, what you have to do as a judge that is hearing mediations is you're almost like, they mentioned this show on TV known as Couples. And I think it was like a couples therapist. And before the therapist, I guess couples would have some kind of argument, and they would come to this therapist, and the therapist would not like make a decision and would not side with anyone. They would hear out, let's say, the first, the husband or the couple, then they would hear out the wife, or vice versa. And they would really listen, really understand both sides. And when they understand both sides, then at that point, then they would give some kind of input, or they would, maybe ask some questions that would get some sort of, some sort of therapy going. So they said that's very, very important. That's like one of the most important things, is to really be able to listen and be able to understand different people's perspectives. So I hope this was helpful. I mean, I thought this was a good CLE. I try to do like a few CLEs, as many as I can. This one was about an hour. It was by Zoom, but it was very interesting. So I like the dynamic, because there were a lot of lawyers, like I said, like 500 lawyers. There were these judges, and there was an attorney as well who moderated, and she's a very experienced trial attorney, very highly respected attorney. So it was a lot of the people from New York, and it was interesting, very, very interesting. To see everyone's perspective and to understand how, the ins and outs of settlements. Okay, everyone, let us know what questions you have. We are here for you, and we will talk to you very soon. Bye-bye.